Senate Judiciary Committee will go ahead and open the meeting, and the committee will come to order. With that, do we have any requests for bill introductions? Senator Wilborn.
Thank you, Madam Chair. I have a Senate concurrent resolution, RS 0819, a proposition to amend the Kansas Bill of Rights of the Constitution of the State of Kansas relating to the right to petition the government, including by citizens-initiated grand jury.
Any objection to the introduction? Seeing none, the resolution is so introduced. Do we have any other requests for bill introduction? Yes, Senator Pyle.
My question is for the reviser, for Jason. I just want to know if he got my message yesterday, because I'd like to get that bill introduced.
Mr. Reviser.
Thank you, Madam Chair. This is Jason Thompson with the Reviser's Office. Yes, I did get the message, and I believe Gordon will be doing that bill request for you. So we should be in touch and be able to get you something on Monday when the committee meets for the final time before the deadline.
Madam Chair, I want to make sure we meet the deadline for a committee bill introduction on that. Thank you.
Any other requests for bill introductions? I want to remind the committee and those watching and listening that the deadline for individual requests for individual bill introduction is Monday, February 8th. Thank you, committee. And with that, then, we will open the hearing on Senate Bill 57. If we could have the bill brief from Mr. Thompson, the reviser.
Thank you again, Madam Chair, and good morning, committee. It's Jason Thompson with the reviser. Senate Bill 57 makes changes to the statutory speedy trial requirement. The bill amends KSA 22-3402 to suspend the statutory speedy trial requirement in all criminal cases filed prior to the effective date of this act until May 1st of 2024. The bill also eliminates the speedy trial requirement for all criminal cases filed on or after the effective date of this act. And finally, subsection L provides that the amendments to the section are procedural in nature and should be construed and applied retroactively. And I'll note that if passed, this bill takes effect on publication in the Kansas Register. And I'll stand for questions.
Thank you, Mr. Thompson. Committee, any questions for the reviser? Senator Corson.
Thank you, Madam Chair. Mr. Thompson, when you say it suspends speedy trial in all new cases filed, it permanently suspends, or permanently suspends until the same proposed May 1st, 2024 date?
Mr. Thompson, if you can answer the question, that'd be great. Thank you.
Sure. Thank you, Madam Chair. Jason Thompson again. So the statute is suspended until May 1st of 2024 in all cases filed prior to the effective date. And then the section does not apply in any criminal case filed after the effective date. Hope that answers.
Would that have the effect of saying that there is no speedy trial right in Kansas in any criminal case filed after the effective date of this proposed change?
Mr. Thompson.
Madam Chair, Jason Thompson again. The conferees will get into this substantially, so I'll say very quickly, it would mean there is no statutory speedy trial requirement, but there are still both federal and state constitutional speedy trial requirements.
Thank you, Mr. Thompson.
Any other questions? Senator Pyle.
Jason, could you tell me where in the Constitution, either federal or state, that the right to speedy trial, what section, where that's at, please?
Thompson?
Yes, thank you, Madam Chair. Jason Thompson again. The federal Constitution, it's the 6th Amendment. And then in the state Constitution, it's Section 10 of the Bill of Rights.
Yes, Senator Pyle.
Thank you, Madam Chair. And then Jason, I don't know whether this is for you or research, but could someone outline for this committee where in statute we suspend constitutional rights in the state of Kansas currently? I'd like to see what other instances there are where we do suspend constitutional rights, if there are. Thank you. Thank you, Madam Chair.
Mr. Thompson, if you could clarify the difference between statutory right to speedy trial and constitutional. I think that would help clarify kind of what we're looking at today.
Sure. Thank you, Madam Chair. Jason Thompson again. And yeah, that's the big part of what the conferees will speak to, is the difference between the constitutional speedy trial right that we cannot change by statute and the statutory speedy trial right that you have in front of you in KSA 22-3402. Obviously, the legislature can impose a more defined right than what's in the Constitution. And in this case, this statute provides either a 150-day speedy trial or 180-day speedy trial, rather than the broader case law and constitutional concept that is provided outside of the statute. And so you have many instances where the legislature defines the contours of the right, but cannot suspend a constitutional right. And you have instances where the legislature has defined a right statutorily and then taken that away, leaving just the constitutional right. I don't have any specific ones right now, but I know we've talked about that in this committee before. But there's two distinct sets of rights there: the constitutional ones that you can't really affect other than defining contours maybe, and then the statutory rights that the legislature has full purview over.
Thank you. Senator Gossage.
We do not seem to have the documents that have been downloaded for testimony.
Thank you. Do we have those online yet? Let me, give me just a moment, committee. Okay, great. And do we have those on the website? Okay, and for those who are looking, I'll explain again how to find the committee documents. If you're following along online, you'll need to go to ks.legislature.org. And under committees, standing committees, Senate Judiciary, if you'll then click on, I'm doing it here, miscellaneous and early release testimony files. You can find the PDFs there, but I'm hearing they're not there yet for today. Yes, that's correct. So you then have to, under early release testimony, click to select date, and a calendar will come up. And I don't see anything for February 4th. Committee, if you'll give me just a moment. Yeah, Senator Thompson?
Yeah, I can help. If Jason could repeat the statute number, you can go to Revisor Statutes on the website and pull up that statute, but I missed the number. If Mr. Revisor could repeat that, Madam Chair.
If you could, Mr. Revisor.
Yes, thank you, Madam Chair. Jason Thompson again. So it's KSA 22-3402. That's the statute that's being amended in this bill. So you could also pull up Senate Bill 57 on the legislative website if you wanted to see the text of the bill.
Do we have confirmation then that's on the website? Okay, yes.
Yes, I refreshed and it was there, but I've been refreshing, but this time it worked.
Great. Okay, well, we're working our way through the new technology, so thanks for bearing with us. With that, then, do we have further questions for the revisor? Seeing none, then we will have our first proponent conferee, Mr. Steve Howe, Johnson County District Attorney. Good to see you, Mr. Howe, and welcome to committee. Can you make sure your microphone is on if you push the button there? There we go.
Good now?
Thank you.
Thank you, Chairman Warren, and thank you to the entire committee for the opportunity to be one of the prosecutors here to speak with you today. I'm going to let Mark drill down on some numbers statewide, Mark Bennett from Sedgwick County, but what I would like to do is just kind of give a sense from the biggest jurisdiction in the state what we're dealing with, and really how we see this would play out in the future dealing with the criminal justice system that has been put at jeopardy with something that's totally outside our control. So the revisers were correct. There's a distinction between constitutional and statutory speedy trial. We are not asking to touch the constitutional rights to speedy trial. which uses a case-by-case analysis to determine whether or not the person's rights were infringed upon. That's what the state Bill of Rights and the United States Constitution says. Kansas went a step further by having statutory speedy trial, so it's an additional right that was bestowed upon people in the state of Kansas. What we're saying is this use of the statutory speedy trial uses an arbitrary number to make a determination of whether or not your rights were infringed upon, and we just feel like using an arbitrary number is not really a good measure as to whether or not speedy trial was impacted. The United States Constitution uses a case-by-case analysis that weighs a variety of factors. Now, in our jurisdiction, we file 6,500 cases a year. And right now, we were lucky enough to have technology. We've done a lot of virtual hearings, but the one thing that we can't do virtually is a jury trial. And that's because a person has a right to confrontation to their witnesses. And so, in civil cases, you can do that. In a criminal case, you cannot. I have to have the ability to look you in the eye, my accuser, and be able to be in that room together. So that's the predicament we're under right now. That's why the criminal cases are in a real jam, because we've had a year delay of no jury trials virtually, maybe a couple around the state, but really no jury trials. If you notice, I indicated in Mark's testimony, I gave him a number of 400 or 500 cases that are post-arraignment, which then that means that in traditional time it would start running, that speedy trial clock, where they're not set for a plea or a motion hearing. So those are really queued up, ready to go. We have 6 criminal courts in Johnson County, and we have 2 juvenile courts. So the maximum capacity we would have would be 8 courts to try jury trials, criminal jury trials. I want to use a little bit of some numbers if you take that. So we have 8 courts. If we have 400 cases as a backlog, if we tried a case every single week by all 8 courts, it would take 50 weeks just to get rid of that backlog. Now, we all know that there's holidays built into our calendar, that we can't expect jurors to come in. We also know that some jury trials don't get done in a week. And then the other component of this, of the 400 cases, is we should continue to have new cases coming in the door. So as we're trying to erode the backlog, like I said, we file 6,500 cases a year. We've got new cases coming in the door. Now, in all reality, if we were to start jury trials today, the difficulty is not necessarily about me or the defense attorney or the judge being in the courtroom. Is how do we get jurors, the citizens of our counties, coming in and feeling safe to be jurors for long periods of time? That's the predicament, and that is what our courts and us have been talking with our health department officials in Johnson County. How do we get to the point where we can make them feel safe? So if you think about it, we can't really turn the spigot on full tilt and go all 8 courts at the same time right now with today's climate. Maybe we can do halvesies, we can do half of them at the same time. And that's because you can't bring in 500 to 1,000 people and pack them into our jury assembly room and expect them to feel safe. And are we really going to create a situation? So even if we went half tilt for at least 6 months, you're talking about, at the very least, in my estimation, in my jurisdiction, taking 2 years just to get rid of the backlog. And then in that 2 years, we continue to have new cases coming into the system and the pipeline. And so when we ask for the time that we're asking for under this statute, it may seem like a long time, but I will absolutely tell you that's how long it's going to take for me to dig out. Now, if we do nothing, what will happen? Well, you know that the executive orders that have been put into place, and you've been good enough as a legislative body to assist the governor in being able to do those executive orders, which then in turn allowed the Supreme Court justice to stay statutory speedy trial. That clock ends the end of March. So if we do nothing, we're left in a situation where every jurisdiction across the state is going to have dozens and dozens of cases that they have to decide, well, who walks and who is held accountable. When I say walk, I'm talking about people who have committed serious crimes walking out the door where there's no justice for victims, no accountability on serious crimes. Because I will tell you, in my jurisdiction, there is no low-level offender sitting in our jail. The people sitting in our jail waiting trial are serious offenders. And so that's the predicament, that's the concern I have, is by no fault of anybody, whether it be the legislature, the Supreme Court, the governor, me, judges, no fault of ours, we've lost a year. And so this is unprecedented. It's not something that's anybody's fault. It's outside our control. And what we're asking is a short period of time to allow us to effect justice for the people of the state of Kansas. And I know I'm not exaggerating, folks. I don't blow smoke. I absolutely will tell you, as a prosecutor of over 30 years, this is unprecedented, what we're facing. And my people will have a really tough 2-3 years to slog through the number of cases that we have to try. And we're not the only jurisdiction, but across the state. And we're asking that you give us this ability to effect justice for all the people of the state of Kansas. Thank you.
Thank you, Mr. Howe. And committee will go ahead and save questions to the end after the conferees have all testified. Next, then, we will hear from Mark Bennett, Sedgwick County District Attorney. Mr. Bennett, welcome to committee.
Senator. Okay, take this down. Might hear me a little better. So I'll start with some of the options we had before this bill was introduced. When this first came to light last March, when we became aware that a shutdown of the legislature and a shutdown of the courts was imminent, we approached members of the legislature to ask for some power to suspend the statutory speedy trial right. The first iteration of the bill that was sort of passed around, that didn't make it through, though, was to simply give the Supreme Court the power to do so. There was some back and forth on that, and I think the final analysis was the legislature felt comfortable with more oversight than simply handing that responsibility off to the Supreme Court. So we didn't come back today asking for that route again, understanding that was already not palatable a year ago. The second option would be to continue to have it tied to emergency orders. Well, then now I'm putting you all in the position of having to decide, do we let businesses reopen? Do we let sports attendees in the audience, that sort of thing? Or do we keep the speedy trial suspended? Tying those two things together, to be honest with you, it just overly politicized the whole affair. So the third option that comes to mind here is the one that strikes us as, at least, whether it's palatable to you or not, at least it's the least political, and that is to just deal with the statute on its face. And that is to say, we have a statutory speedy trial in Kansas, which sets numbers at 150 days for in custody, 180 days out of custody. And we need time to work down, as Mr. Howe said, the backlog of cases that have built up over this past 10 months, 11 months, while we've been out of, unable to try cases to the extent we were before. I want to make sure that the distinction is clear here, because a couple of the questions that were asked about is there any other instance in which we're suspending a constitutional right? Just to be really clear, this doesn't suspend a constitutional right. I can't touch the Constitution. The constitutional right to a speedy trial remains. If this statute didn't exist, you would have a constitutional right to a speedy trial. There are states that do not have a statutory speedy trial right, and they still have the constitutional right to a speedy trial. And how that's assessed is, if a defendant thinks he or she has sat too long awaiting trial, in custody, out of custody, whatever, they have a right to ask the judge to make a determination. And there's a case law in my written testimony here, and it dates back to 1972. This is not some novel or new thing. If you look up Barker versus Wingo, and for the lawyers in the room, if you Westlaw that, I think that, it's in the tens of thousands of cases have cited Barker versus Wingo. And there are certain criteria that the judge is to look at. The length of the delay, the reasons for the delay, whether the defendant ever asserted his or her right to a speedy trial, the prejudice to the defendant, meaning did a witness die? Did evidence, was it lost over that span of time? Those rights remain, no matter what this body does. We are powerless in the states to adversely affect or take away a constitutional right. Kansas simply saw fit years ago to say, in addition to the constitutional speedy trial right, we're going to have a very specific set of numbers on a statutory assessment. And in terms of that, we've even defined it more specifically. The right to the 180 days, 150 days runs from the date of arraignment, not from the date the case is filed or the date the act took place. So you are even free to define what statutory speedy trial means in your own statute. The issue is, as Mr. Howe has said, when this ends, and by that I'm talking about the suspension that has been previously tied to the emergency orders, when this ends in March, if this body, if the legislature does not take action, I will have 150 days to try everybody who's in custody and 180 days to try every case that's out of custody. And there's an argument, well, just dismiss the cases and refile them when you're ready. Sure, we could try that. There's also some case law that says that the prosecution suspends a case, or dismisses a case to gain a tactical advantage, that we're not able to refile the case. So let's talk about the numbers. Well, why don't we just get to work? All right. Here's the numbers we're dealing with. On the second page of my written testimony, I gave just a smattering of some of the responses I got. In Butler County, there's 86 felonies waiting trial. Douglas County, 150 to 170. And it just goes through the list here. Lyons County, 62. You get to Sedgwick County, I have 648 cases awaiting, that are post-arraignment, awaiting jury trial. I have another 1,000 or so that are filed, that are waiting for the preliminary hearing and arraignment. Let's just talk about the serious cases, the most serious cases in Sedgwick County. I have what's called off-grid, level 1, level 2, level 3. So we're talking first-degree premeditated murder, Jessica's Law, kidnapping, second-degree murder, ag-crim sodomy, those kinds of things. That's what's the 1s through 3s. The lowest, the least serious level 3 I can think of would be like an ag robbery, ag indecent liberties with a child that's over 13. That's the category of cases we're talking about here. I had 138 of those. And so, all right, let's just prioritize and try those in the next 150 days. To do so, from the date the clock starts ticking, I would need about 5,300 jurors to walk through the courthouse doors in Sedgwick County. So from April, May, June, July, I need over 5,000 jurors to walk through the doors just to try my level, the off-grid level 1s, 2s, and 3s in Sedgwick County. I have 113 people, actually I think the number's up to 115 now because I wrote this a week ago, sitting in custody in the jail in Sedgwick County, awaiting trial on some degree of homicide, murder, anything that involves the death of another human being. What I'm getting at is there is no feasible way for us to try these cases within 150 days. And if it sounds hyperbolic, I don't mean for it to. I mean for it to sound decidedly pragmatic. If we don't have an extension, there will be cases lost. There will be homicides and murders and sex crimes where the accused don't get their day in court, the victims certainly don't get any semblance of justice, and the community is less safe as a result. What we're asking for here is a suspension. Just suspend the statutory, the 150-day, 180-day time frame. Let us do our work without that added, frankly, arbitrary number. Let us work simply on constitutional protections that are afforded to everyone, that we are not asking you to affect, and you couldn't if you wanted to. We are asking for the power to simply get back into the courtrooms when the Supreme Court and our judges say that we can, and start bringing jurors in. I will tell you, in Sedgwick County, we started jury trials in September. We have 10 judges who try our cases, and then another 3 who do juvenile. But we've only got 2 courtrooms that a cost of about 40 grand a piece that are outfitted with plexiglass. They're affectionately referred to as the hockey rinks. That's what it looks like when you're in there. Plexiglass everywhere. 2 of them outfitted. It cost us nearly almost $100,000 to do so, which is something Sedgwick County is able to do. But I suspect most of the smaller jurisdictions do not have access to that kind of money and those sort of resources. And so even in that context, we've only been able to try up to 2 cases a week. So we are limping along. And to give you by way of comparison, in January, February, and up to March 18th of last year, we tried 26 jury trials on felonies in Sedgwick County in the first 10 weeks of the year. Since then, the rest of the year, we tried 6. So that's what we're up against. The passage of this bill would simply give the courts of this state the power to get the work done that we need to get done without the sort of Damocles hanging over our head of 150 days or 180. Because at the end of the day, there is no exception under the statute. If there's a fire in the courthouse, or the judge has a heart attack, or there's a snowstorm that people can't get to the courthouse, there's no exception written into our statute. If, well, we got the COVID going on here. This is not realistic. Doesn't matter. The statute as written is unforgiving. If we don't get the case tried and a jury sworn out by that 180th day, the case is dismissed with prejudice, never to be refiled again. It happened in Douglas County last year, a homicide case, the Queen case, that there was a miscalculation by 3 days. And on the Court of Appeals, when they reviewed it, said you started 3 days too late. Case dismissed with prejudice. It's on review to the Supreme Court, but to be candid with you, I don't know how the Supreme Court could come to a different assessment of it. It's black and white, which leads me to the final portion of this bill, and that is the membership of the KCDA has asked that we forward this bill, at least put it to this body and to the legislature. Is there still a reason in this day and age to have this arbitrary number, 150 days, 180 days? The cases that are on file right now, the right has vested. There's no argument about that. If you've got a case on file in Kansas right now, your right to a statutory speedy trial is there. And so all we can do with those is suspend. But as we move forward, do we need a statutory speedy trial right? The reality is it does not function as a speedy trial statute. It functions simply as a bit of a parlor trick with respect to a math equation. If that seems a little hyperbolic again, I don't mean for it to, but it's the truth. Here's what I mean. When I get to an arraignment and the judge says, all right, is this for trial? Well, we're demanding a trial right now. Okay. My first available date is 120 days out, says the judge. Okay. That first 120 days, who does that count against? Me. I didn't ask for 120 days. I might be ready to try it in 2 weeks, but the judge's calendar is not free again until 120 days out. So we get to that 120th day, and the defendant shows up. I've got a cop who's out sick, who has, there's a witness who didn't show up. It happens a lot. And we say, Judge, I'm sorry, we can't go today. All right, you now have 30 days to get that case tried, and I got to get you squeezed back in to the judge's calendar, which was already still set out for 100 and some odd days. That counts against me. Now, was it the state's basis for the delay? Did this guy's speedy trial right, was it denied because the state didn't move fast enough? No, it's because of calendaring issues. If the defendant continues the case 10, 12, 13, 14 times, he's free to do so. But if we can't get it tried on the court's calendar within 150 days, then it's a violation. My point is, this is more philosophical, frankly. It's just a public policy issue. If we want to have a speedy trial statute, we could certainly come up with one where someone could have a right to ask a judge to make certain findings and say, I want on the next available date. But that's not what happens under our current statute. So our association asked us, conferees today, to at least ask you, would you consider repealing it? If that's dead on arrival, I get it. If you want more time to consider it, I understand that. The only thing I would say then is if that section is not palatable to this body or to the legislature in general, that'd be subsection K, then at least we need one amendment, and that is to J, the suspension, which is simply to say all cases need to be suspended. Because I can't have a situation where, okay, the date of effectiveness that this new bill would be passed, that's the date goes into effect. And the way it's written right now, if you just cut K out and only leave J, it would read that all cases previously filed until today, it's suspended. And then it would be silent about new cases, meaning those new cases would be right back into 150 days, vying for the same spots the older cases are there. So my only request is, if we're not going to repeal, then just change that language to say, then it's just suspended across the board. old cases, new cases, everything, to give us this chance to work these cases down. I'm sure you have questions. I understand we'll take those at the end, but I'll just, again, tell you that from my perspective, in my jurisdiction, I have zero interest in delaying things. Since November 30th of this past year until about 10 days ago when I first wrote this testimony, I think we had worked down 120 felony cases off the jury trial docket. So we are continuing to move cases. And the final thing I'll say is this. Well, okay, you know, you want 3 years. That seems a little much. Could we do it in a year? Sure, if we were open for business, if we weren't wearing masks here, realistically, does anyone think that this state is going to be back to pre-COVID normal before July, August, next fall? So I'm asking for 2 years. The problem is this first year is a wash. So I need the first year to keep continuing to limp along until sometime in the fall, and then 2 years to actually get down and be able to try 5, 10 cases a week in every jurisdiction across the state to work this backlog down. If we don't do that, if we don't have the 3 years, I get it. Make no mistake, I'm asking for 3. But if that is not palatable, my only request is, if you're going to give us 2, then make it through May of 2 years from now, so I at least have the ability to come back during that session and go, yeah, we're still nowhere near this. I'm asking for 3 because of the reality that we're in. It is not going to be an 11 or 12-month delay in jury trials. It's going to be something more like 20, 22 months before we're back from March of last year until we're back to something that allows me to say I need 5,000 jurors to walk through the courthouse doors in the next 3 months, in Sedgwick County. Very last thing is, also need to remember one final point is, well, it's only 50 trials a week or 50 trials a year. Why can't we do that? There aren't that many attorneys in the state who are qualified to handle murders and child sex cases, etc. The busiest year I ever had, I tried 2 capital murders, a child death, Jessica's Law case or 2, and I don't know, half a dozen other cases. I think I counted it up one time. I misspoke when I spoke in front of the House. I think I was in trial 28 weeks that year. It's debilitating. A person can only try so many cases a year and try them effectively. We cannot expect public defenders and prosecutors to come in and say, try one after the other after the other. It is not realistic, and we'll have ineffective assistance of counsel claims as well. And 10 to 15 cases a year is a monumental task for any attorney, and we're going to ask them to do that for the next 2 to 3 years as they work these things down. So another thing to consider. I appreciate your time. I know it seems like a big ask, but it's a big situation we find ourselves in. Thank you.
Thank you. Next, we'll have Brandon Jones, Franklin County District Attorney. Please introduce yourself and welcome to committee.
Thank you. Can I remove this for the Chairman Warren and members of the Senate Judiciary Committee? Thank you for the opportunity to speak. I am Brandon Jones, the Franklin County Attorney, but I'm also the president of the Kansas County and District Attorney Association. And luckily, my 2 colleagues went before me, so I'm going to try to keep mine rather brief. But they represent essentially the 2 biggest counties, biggest districts in the state. And I'm here kind of more to speak on behalf of the smaller districts in the state. I'm from Ottawa, Kansas. I am the county attorney. I have 3 assistants and only 6 support staff. Our backlog there right now is only, and I just put the list together again yesterday, is 35 cases. Not even close to what they have. But with only having 4 attorneys in my county and only having 1 judge assigned to hear those cases, my situation is just as dire. I talked to the Smith County attorney. They've only got, I think she said, 15 backlog cases. The problem is she shares her district court judge with 6 other counties. The district court judge makes it to her county once or twice a month because that district court judge has to do those other 5 counties plus all their divorce cases, their civil cases, so that they don't have dedicated criminal court judges. So again, her situation is just as bad on a smaller scale. I think we could have this room full of prosecutors from across the state. This is, in my 21 years as a prosecutor, is the most pressing issue that I've ever seen us face. I've testified before, but nothing's been more important than the fact that we take action on this. I was quoted in testifying in front of the House Judiciary Committee of saying that at 35 cases, if we try 1 a week, You know, it's going to take us close to a year to try that down. My judge saw the quote in the paper, and he called me and said, hey, just so you know, we're not trying a jury trial a week for 35 straight weeks. And I said, sorry, Judge, I don't want to be taken out of context, but the point being, he's got a domestic docket he has to do. He has civil cases he has to do. He has vacation time. He knows that defense counsel has vacation time. So even at just 35 cases, we're not going to be able to try those in just a year. It's going to take, like what Mark and Steve both said, it's going to take a couple years to get this backlog brought down. And just so you don't think that we're just up here complaining and not trying to make any solutions, we're still slogging along in the court system. We are still having hearings. We're still going to prelim. We're working out cases on a daily basis. We have a docket going right now that I would normally be covering, but I'm up here, so one of my assistants is covering it. We have set up at the end of this month a mediator coming in, a retired Johnson County judge, who's actually, we're going to take 4 or 5 cases that are set for jury trial, and we're trying to prioritize people who are in custody, and we're going to try to mediate those. Non-binding, but as a way to try to work out our differences and get pleas resolved and get this backlog worked down. So we are open to ideas, and we are trying our best, given the situation, to get our caseload down. But the reality is, at the end of the day, we still have a lot of cases that we're just not going to be able to get tried in 150 or 180 days whenever that gets released. In our district, we just found out last week that the Supreme Court finally approved our jury trial plan, which is to go across the street to our municipal auditorium and try to have the litigants up on the stage and the jurors out in the audience. That being said, our district court judge says there's no way right now I can try to still ask jurors to come in even in that situation because of the rampant spread still and the high numbers of COVID. And so I think everyone knows that we're looking, like what Mark said, I think you're looking at summer at the earliest. We're going to realistically, even under the situations like the hockey rink in Sedgwick County or in our big municipal auditorium, before we're actually able to start trying these cases. So I do think it's realistic that it's going to take us, maybe not necessarily in Franklin County, but in Sedgwick and Johnson County, it's going to take until May of 2024 to work through these. And that's why we're asking for that. And then the last thing I'm going to say is just again on the statutory speedy trial, it is simply a numbers game. The one thing that it doesn't take into consideration that has always seemed unfair to me is what happens if there's a snowstorm and the court gets sick. That time counts on the state. If we want to rework statutory speedy trial to make it to where just the state's continuances, when I ask for continuance, it counts against us, we have no problem with that. And quite frankly, in my 21 years, I don't think I've ever had an issue with not getting someone tried in statutory speedy trial before this situation. But now it's just not possible at this point. One final thing before I step down, because I don't think either one of my colleagues hit on this. In other states that actually do have statutory speedy trial, the remedy doesn't have to be dismissal of the case. For example, if someone's in custody and we don't get him tried in 150 days, instead of dismissing a murder case and denying justice to the victims and the community, let him out of jail. Let him go on free on bond. There are other ideas that we are all open to working with you if it's not palatable to just get rid of statutory speedy trial, despite the fact that we still have constitutional. We're open for suggestions. We just want a workable situation. And with that, I thank you all for your time this morning, and I'm ready to answer questions whenever you're ready. Thank you.
Thank you. Next, we have Jeff Easter, Kansas Sheriff's Association, and he's joining us on WebEx. Go ahead and introduce yourself, and welcome back to committee.
Good morning, and thank you. I'm Jeff Easter, Sheriff of Sedgwick County, and the Legislative Chair for the Kansas Sheriff's Association. I'll just be very brief. I've submitted written testimony. The other conferees have really discussed the immense issues that the criminal justice system is facing due to the courts being shut down. Currently, I have 1,419 inmates in the Sedgwick County Jail, of which we now have 115 that are charged with the crime of murder. It's changed by 2 since submitting this testimony earlier in the week. The issue is about a little over 75% of the inmates housed in the Sedgwick County Jail are charged with serious felony crimes, mainly violent criminal offenses. And so, and we're continuing to see that population grow because of the court system being shut down. But that doesn't mean that we should just let these folks out to either A, commit more crimes, or B, because the victims aren't going to see justice due to the fact that if, you know, the speedy trial thing is not resolved in this bill, and folks are not held accountable because their case is going to be dismissed with prejudice. And so we absolutely support this bill, and mainly to ensure that justice is served, not because of a statute that limits the ability for speedy trial, and also due to the fact that we're living in unprecedented times where we've never had to face this. Thank you for allowing me to testify today, and I'll stand for any questions at a later point.
Thank you. Next, we'll hear from Greg Smith, Johnson County Sheriff's Office. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. My name is Greg Smith. I'm with the Johnson County Sheriff's Office. I'm the Special Deputy for Government Affairs. I'm entering my 24th year in law enforcement, and I spent, some of you know me, I spent 6 years in the legislature. To not run the risk of being cumulative here with all the information that's come out, I'll simply point to my written testimony, but highlight a couple things and bring up some things that we had just found in the last couple days doing research for this. Back in September, we testified in front of the Special Committee on KEMA and listed 3 critical areas that we felt needed to be addressed as soon as possible, and one of them was the speedy trial issue. Listening to the questions at the beginning of the hearing to the revisor's office from some of the senators, there is definitely a difference between statutory speedy trial and a constitutional speedy trial. If we were a state that did not have a statutory speedy trial, it would be based simply on the Constitution saying that the defendant has the right to a speedy trial, and what that is determined by the court. If a defendant feels that they've been in custody too long or their trial hasn't started yet, they can file a motion, and that's what goes on in federal court. We look to see what the federal courts are doing during this COVID thing, and almost without exception, almost every federal district court cites Chapter 18 U.S. Code Section 3161, which has to do with time limits and exclusions on courts. The Kansas District Court has done it, the federal court. But what U.S. Code Title 18 does is it says that the ends of justice are served by continuing a case because it outweighs the interest of the parties and the public for a speedy trial. This pandemic clearly outweighs all those other interests. That may be language that the committee wants to look at if you want to continue with some sort of statutory speedy trial thing. We are in support of the bill as it is, and we're happy to have a conversation to assist if the committee thinks that would be beneficial. But the bottom line is, this is about justice being served, and it can't be served if people are let loose because of an arbitrary time period, unable to be tried for a crime they may or may not have committed. But the bottom line is, if you're the victim or a family of a homicide victim, and you're told, well, we can't try that person because the time limit ran out, there's no getting over that. There's no recovering from that. So in the interest of justice, I think that this bill should be passed, and be happy to stand for questions at the appropriate time, Madam Chair.
Thank you. Do we have any other proponent conferees in the committee meeting room or online? Seeing and hearing none, then I'll direct the committee to, in your committee folder, you have proponent written testimony from Natalie Chalmers, Solicitor General's Office, and also in your committee documents, you have the fiscal note. You'll see that there would be a negligible fiscal effect on judicial branch operations, and the Office of the Attorney General states that the estimates there would be issues raised in appeals, but can all be handled within existing resources. With that, then, we will open it up for committee members' questions for any of our conferees. Yes, Senator Baumgardner.
Thank you very much, Madam Chair. I just want to, I don't have a question so much, but I have a statement because I think it's very important, the variety of conferees that we have presenting to us today. And it absolutely is not lost on me with all of the backlog that's going on in our DA desks, that they would take the time to be here indicates just how important that backlog is and the importance of us addressing that. Particularly appreciate that it was put in very clear context for us, the impact of rural counties, since the judges are serving multiple counties, so they do have to work in coordination. So just appreciate that my district attorney was here, but also the others that were here to present to us. Thank you very much, Madam Chair.
Thank you, Senator. Very well said, and a hearty thank you to all of you who have appeared today to testify either online or in person. My district attorney is present today as well to offer testimony, and appreciate from across the state you all appearing today. With that, Senator Haley, questions?
Well, let me start by echoing what you have said, Madam Chair, and Senator Baumgardner have said. I too appreciate that we have such an array from across the state and our district's attorneys. As a former ADA myself in Wyandotte County, I should also mention that I've heard from Wyandotte County District Attorney Mark Dupree on this issue and the concern for the backlog of cases that this unique circumstance has created. So I genuinely appreciate these gentlemen that have been here today and those that have appeared on WebEx as well. My question is how far we potentially kick this can down the road. 3 years out has been suggested. And I do know we don't exist in a vacuum in Kansas with this pandemic and the responses to it. I think one of the district attorneys alluded to other solutions that are being found in other states. Specifically, what has been the variables that have been allowed. And what I'm getting to, Madam Chair, is, and I don't know who wants to respond to it, we can come back and revisit this next year in this committee and look at the statistics that have been presented, where the backlogs are, in which districts they are. I am concerned about a 3-year moratorium for speedy trial. And I would hope that we could look at what other states are doing as well to address it.
Thank you, Senator. Does any conferee wish to address the senator's question? Yes, please introduce yourself, and thanks very much.
District Attorney in Sedgwick County. Senator Haley, it's good to see you. I will tell you that we are not alone in Kansas in this situation. There's no state. I have staff members who join a discussion every Friday with the National District Attorneys Association that we talk to panelists across the United States, all 50 states. And not every week are involved, but we hear from folks from King County, Seattle, Cook County, Chicago, East Coast, you name it. So what are you doing? Who's got it figured out here? And the answer is everybody's in the same boat. We all operate under the state laws may differ, but I'll harken back to what Steve Howe said to begin with, and that is the distinction here on jury trials as opposed to everything else, preliminary hearings, probation violation settings, et cetera, is all of those are really artifacts of statute. The preliminary hearing is not found in the Constitution. It's a statutory right. So you can set your rights how you want. The Constitution gives every person accused of a crime the right to ask for a trial by a jury of their peers. And all those other things kick in, the Fourth Amendment, Sixth Amendment right to counsel, Fifth Amendment right to silence, et cetera. But among those is the Confrontation Clause. There's only one exception. Coy versus Iowa is a case from the 80s, and there's a case called Maryland versus Craig that talks about that. For children, like little kids, they can testify by what's called a closed circuit television, but very rare circumstance. I was a sex crime section chief in Sedgwick County for 15, 16 years. Tried, don't know, 70, 80, 100 sex crime felonies. Twice in my career was I ever able to meet all the criteria to have a child testify like that. That's it. Everyone else, if you accuse me, I don't even care if you're accusing me, if you are a witness against me, if the state wants to bring a witness to testify against me in a case, I have the right to sit in that courtroom, look in that person in the eye, have my attorney look them in the eye and ask them questions. Those rights have been enumerated over and over again. There's no way around that. And so, to answer your question, other states are doing what we're doing. We're trying to do as many cases as we can by way of video testimony, by way of, you know, if you can set up plexiglass and all these other things. But in terms of trying jury trials, no one is open for business right now. We are all limping along, doing a few here, a few there, when all the parties and the litigants agree that they're willing to do it under those circumstances. So it's not as if we're missing the boat somewhere and there's a great way to do it. Everybody's under the same, has the same hurdle to cross.
Thank you, Mr. Bennett and Senator. Senator Thompson.
Thank you, Madam Chair. I think it's clear that our court systems, particularly our DAs, have been placed in an untenable situation because of this, not only because of the pandemic, but the response to the pandemic. And I think this situation more clearly illustrates how we need to return to normal and get rid of this emergency declaration as fast as humanly possible. The longer it's delayed, the longer the situation is going to draw out. And I know I'll probably get skewered for this statement, but Dwight Eisenhower, native son in Kansas, asked thousands of men to storm the beaches in Normandy. 72,900 died. They knew going in they had bullets coming at them. We've got a virus. We also have mitigation situations that we have in place, very rapidly coming into place. And this is not for these gentlemen, not for our court systems, but for our leaders who are extending this emergency, in my opinion, much longer than it needs to go. That we need to get, just for this case illustrates more clearly to me that we've got to get things back to normal as fast as humanly possible, not only for our court systems, but also for those who are awaiting trial and wishing to be adjudicated. So that's just a statement. I support their efforts here. I just think it's a good illustration of what we're faced with. Thank you, Madam Chair.
Thank you, Senator. Senator Corson.
Thank you, Madam Chair. I just wanted to I had a question for Mr. Bennett. First, I want to echo all the previous statements about thanking all of our proponents for their public service. You know, I'm going to single out Steve Howe and Greg Smith from my county for their public service. And I do think everybody is operating in good faith, and I want to be very clear about that. And Mr. Bennett, I just want to make sure that I understood. It sounded like you would be amenable to us doing the suspension until May 1st, 2023, at which time we could get together, revisit where we are, understand what caseloads look like, and if a further extension was necessary. I think this crisis has just taught us that whatever we think will happen in the next 6 months or a year, the reality is going to be very different. So I just want to make sure that that was accurate in my interpretation of your testimony.
Yeah, so to be as clear as possible, we're asking for 3 years. But I understand.
Identify yourself again.
I'm sorry, Mark Bennett, District Attorney in Sedgwick County, proponent of the bill. So to be very clear, we're asking for 3 years. And for the reasons I already said, I think it will take 2 full years to do this, and we don't have the first year really at our disposal. And so if you give us 2021 and 2022 only, I know we'll be back. What I'm saying is I also recognize, I've been up here to testify 50, 60 times over the last 20, 25 years, and I understand how legislation is made, and there's compromise, and there's nonpartisan haggling that goes on, and I understand that. What I'm saying is, if you're going to do that, then at least give us until late in the session of that year so that we can come back. It's not anything that I am asking for, but I recognize the situation we're in, and frankly, I'm not in a position to bargain. I need it. I need whatever you can give me.
I appreciate that. Well, I mean, I think May 1st, 2023 could be appropriate. And how long has Kansas had a statutory speedy trial right?
The statute, but I think it started in, well, first of all statutes with respect to criminal cases date back to 63 when we codified our law. Everything else prior to that was common law. So somewhere in that stretch, I can't remember if it was in that first, in 63 or sometime thereafter, we've had it. It's been changed over time from 90 days to 150. We've moved the needle here and there, but the statute's been in place for as long as I've been a prosecutor now for 20. I'm in my 6th year. It's been there my entire career.
Okay. I mean, because my view on that is that these are unrelated issues, whether or not we have a statutory speedy trial right in normal times and whether there needs to be a suspension, because right now we're going through an unprecedented time. I view those as apples and oranges, and so I'm looking at those as completely different issues that I think we've sort of lumped together here, but to me, they're separate issues. But I thank you for your service. I thank you for your answer to my questions. Thank you.
Senator Gossage?
Yes, thank you. And you may stay if you don't mind. And thank you all for being here, and thank you, Madam Chair. I certainly understand the gravity of this situation. My, I guess, question is, how is it that what we're doing today, by having remote testimony, by making adjustments through government, et cetera, that they were not able to see the person that is accusing them, or being able to see one another, as you mentioned in your testimony, that they could not see each other via WebEx or, or some other, system, Zoom meeting, whatever. Is there any way to change that? Not really to address this. I'm not saying I'm against this. I'm just asking that question.
Yeah, it's one of those things where it's never been an issue before, so it's never come up. It has come up in 2 contexts that I'm aware of. 3, really. One is dating back to the 40s and 50s in the federal, and if you look at the Southern District of New York, there were mafia prosecutions where people did not want to come in and be seen in a courtroom, so they would testify behind a screen. And that was immediately challenged for confrontation. I was not able to confront the witness against me, and there was some case law that came out of that. The second was early 80s, that Coy versus Iowa case that had to do with, well, there's a case in Kansas then that came out of the Chisholm is the name of the case, and that has to do with child witnesses. And we have a statute that was then passed as a result of the Coy versus Iowa. So it's one of those things that it's not an issue until it becomes one, until the Supreme Court of the United States weighs in. Then somebody 30 years ago came in and said to the legislature, all right, we need a statute that addresses this. So that's how these things happen. The final one has to do with witnesses who are just unavailable. There's a case called Crawford that came out in 2004, and there's some other case law, Apprendi, and a few others that have come out since then. All Supreme Court of the United States. There has never been a situation since the 1918 Spanish flu pandemic. There has never been a situation, though, where a person could not get into a courtroom and physically be across the room from their accusers, from the witnesses. And so, beyond that technology, it wasn't there other than closed circuit. So there's never been any cases where a judge says, look, we're just going to have to throw up our hands and try this by WebEx. It's not happened yet. And so until the Supreme Court of the United States weighs in and says this does or does not pass muster constitutionally by the Confrontation Clause, we don't have the ability to do that. We are waiting for the Supreme Court to tell us whether any of these platforms would pass constitutional muster. I can only tell you that Justice Scalia, during the Crawford decision in 2004, basically laid waste to all of the exceptions, Ohio versus Roberts, Idaho cases, and I'm not just citing these cases, but these were the cases I came up with, thinking, okay, this is how you do it when you have an unavailable witness. And Scalia said, it's all done. That's all. I won't be as blunt as he was, but none of that passes constitutional muster. The rubric, his quote, the rubric by which we achieve justice is to sit in a courtroom, ask questions, let a jury read the face of the other person. There's no substitute for that. That's the last pronouncement we have on this. And so to say, why don't we do WebEx? Why don't we do Zoom, whatever? I don't think there's a judge in the United States who would think that until the Supreme Court says, okay that will ever be constitutional.
So a follow-up question, if I may, Madam Chair, and that is, I'm a big fan of Justice Scalia. However, in 2004, of course, we didn't have anything close to COVID. This has been going on. COVID has been around for a year now. So has anybody brought this, or is our Attorney General going to be bringing this forward?
You have to have, this is not something to go to the Supreme Court of the United States. You say, I have a question. I need an advisory opinion. They don't do that. You have to have a case that is tried using Zoom. The person has to be convicted. Then they go to the Kansas Supreme Court, and they have the Supreme Court say yes or no. Then they go through the 10th Circuit and all those appeals, and then it would go to, frankly, the bottom line is, even though it's been a year, it's a 3 to 4 year process to get you to the Supreme Court, and that requires the trial in the first place. So we are probably 4 or 5 years out before there will be a case. There absolutely will be a case, a Miranda, some huge case that we'll all know coming out of this. Looking back, oh, that was the one where they decided. But we're probably 2 to 3 years away from getting that from the Supreme Court.
Thank you for your thorough explanation.
Thank you.
Thank you, Mr. Bennett. If you could wait just a moment, Mr. Bennett. Just a couple of clarifications for the committee. I think that was brought up by Mr. Bennett's testimony for the revisor. If the bill is passed as written, does subsection K, that repeals the statutory right to speedy trial. Is that correct, Mr. Revisor?
Thank you, Madam Chair. This is Jason Thompson. Yes, so the provision in subsection K on page 3 is the one that says the section will not apply to any case filed after the effective date. So that effectively repeals statutory speedy trial. And the district attorney's suggestion in amending subsection J to apply to all cases was accurate as well. We could definitely make that change if that's what the committee desired.
Thank you. And then we have a brief question, and I do have to ask you, Mr. Bennett, if you could be brief in your response, because we do have 3 opponent conferees we need to hear from. I think Senator Haley, you had one brief question, and then Senator Pyle.
Well, I'll couch it then, Madam Chair. I appreciate the time. Instead of a question, is a statement for how we might have what the problem is, the devil in the detail. The big issue here, and Justice Arnold Berger has spoken to this, is pretrial detention. And of course, the longer those who are languishing, waiting for their trial, who cannot beat their bail. And that's a big issue, and I know she's tried to address it. So if there's significant ties, Mr. Bennett, Mr. Howell, Mr. Jones, Mr. Dupree, and Abstencia, and others, this is the concern. If the defendant or if those who are accused of it can meet that, they don't want to languish waiting for the extension in their trial. And I just make a statement. I know we're going to probably hear from some opposition. They may raise that issue, so I could just wait until that particular time, but I want to throw that out. We've got to do something differently.
I'll say one.
Thank you, Madam Chair.
Even if they're out, that only buys us 30 more days from 150 to 180.
Thank you. Senator Pyle?
Thank you, Madam Chair, and I don't want to seem like the devil's advocate here, but these are questions that I need answers to. In the whole realm of the court, when the courts were closed down last year, and all of those salaries and pay, how many of you, I mean, I'm talking about budget issues here, but so all of these cases got backlogged and are piling up, but did any of the salaries and did any of that stop? Any of that funding stop? No. So the costs are all still there, but we're piling up all this work. So in effect, we're creating a budget crisis.
No, we're going to continue to work under the budgets we're under. I'm not asking for additional money. I'm asking for additional time.
Okay, thank you for that answer. Are you aware of any lawsuits that concern a speedy trial?
There will be motions, not lawsuits. There will be motions within existing criminal cases saying I was denied my right to a speedy trial. All of that has been stayed both at the federal level and the state level. The feds aren't trying cases either. Their courts are literally shut down. In Sedgwick County, I've got 10, 15 courtrooms open today. We're doing work. We've been doing work this whole time. We just can't do jury trials for all the confrontation clause and those reasons.
So on those issues, who will oversee those? The courts.
Yes.
Okay.
district court in Sedgwick County or every county in the state, I'm charged in your county and I want a speedy trial. I didn't get one. I filed my motion. The district court judge there will decide. It can then go to the Court of Appeals in Kansas, Supreme Court. Ultimately, if they want, take it 10th Circuit in Denver, potentially Supreme Court in the United States.
So explain to me, Madam Chair, if I can. So explain to me if in one of these, how'd you say it? Motions that they were denied their right to a speedy trial. What is the consequence if they win?
Remedy is they're released, case dismissed.
That's it.
Now, they can come in later and say, I want to sue for the time I spent in jail on a crime I didn't commit, but that's an utterly different matter. There's no, the minute you're let go doesn't mean there's a check that gets written by the state of Kansas for you. Your remedy was you got your case dismissed.
Okay. That explains something to me, Madam Chair, and I appreciate that. Thank you.
Thank you, Senator. Mr. Bennett. I think, Mr. Howe, did you have a comment in response to the senator's questions?
Just on the point that you asked, Steve Howe, Johnson County District Attorney, you asked about whether there are being motions requested. I can tell you a bevy of criminal defendants are already chirping about speedy trial, and the courts are having to make findings that, you know, we're on an executive order, it's been stayed. So this is a warning shot of it's coming, and we're going to have that battle through the appellate court system, but those objections are being lodged, and then the courts are having to make findings about why we are not able to go to trial. And Senator, I would also say, my people are in court every single day from 9 o'clock till 5 with the court. And so by virtual, we can do just about everything but one thing, and that's jury trials. And so we're doing the rest of the business.
Senator Pyle.
Thank you, Madam Chair. You raise a question then. Okay, so if that is filed, that paperwork's filed, and their ruling's in favor, and they're dismissed, okay, let go. Is there ever potential to retry those?
No.
It's done.
It's done.
So they can't be tried. I thought that's, yeah.
And the other problem is by the time we find out about it, across the state, we're going to have hundreds of cases that are going through the pipeline. And then if we're told, oh, by the way, those cases are all dismissed or the convictions are overturned. And so the predicament we're in is, and what we're scared about is we don't want to get in that situation where we're told after the fact that we did everything wrong by the appellate courts. And so that's the danger, and that's the reason why this is so important, asking for this stay.
If I could follow up, is there any, so if that case was dismissed, would the, I'm trying to think, I'm assuming these are defendants. Would the plaintiffs have any recourse?
Zero.
Zero recourse?
Other than maybe filing a civil lawsuit for injuries or something like that, that would cost the victim thousands of dollars, but they have no other recourse because that is a dismissal with prejudice. And that's the draconian aspect of the speedy trial bill is you don't get a second bite at the apple. You're done. And that's what scares us.
So follow up, if the court didn't dismiss, what's the consequence?
If we don't dismiss, then it goes through the process. If they're convicted, and then they would have an appellate issue to bring before the appellate court, the Court of Appeals or Kansas Supreme Court. And as Mark talked about, going through the appellate process, and depending on those results, they would have a right under the Constitution, perhaps, to also challenge to the United States Supreme Court. But I will tell you, I agree with Mark. That's a 3 or 4 year lengthy process to get to that point.
But the court does oversee, so the court is going to be the one making the decision whether to deny that right and dismiss the case, whatever. So it's the court then that's going to decide we're just going to keep these open and we're going to deny the fact that your right to speedy trial has been infringed. They're just going to, they can deny that. What's the consequence to the court?
I mean, that's their job, and we can appeal to the United States Supreme Court, and we've been successful in overturning the Kansas Supreme Court, but there's no guarantees, and there is no recourse.
So it appears to me, though, that if the court denies that complaint, that their rights have been violated and denies it, but that court case just stays out there and is there. That criminal, it's there. And they're not released. Yeah. So why do we need an expansion? It seems to me that the court has the ability to deal with this, and yeah, it's going to pile up, but eventually it's going to be dealt with.
Well, but what we're saying is the number of cases we have, Senator, we can't get the, I mean, the statutory speedy trial is just a number calculation. There is no physical way that we can get all those cases tried in 180 days. It just won't happen. And so the court, at the district court level, just go count numbers and go dismissed.
But there's no consequence to not getting to them.
The consequence is dismissal.
Only if they win their to the courts, if they win their motion to say that their rights have been infringed, and the court is over that, and the court just denies that, there's no consequence.
To the court or to the defendant?
To the defendant.
Well, if they win their argument, their case is dismissed, and we're left without being able to get justice. If the court denies their motion, then it goes through the appellate process, which takes years. But ultimately, it is just a numbers game. And so, as we know from the Douglas County case, it's just raw numbers. They calculate the raw numbers. And I'm telling you, we cannot in the next 180 days, effective March 31st, try our cases. It's just not going to happen. And then the court will just calculate the days, and the cases are going to get dismissed. And that is just not my jurisdiction, but across the state. That is the reality.
You're predicting all of these criminal cases are just going to get dismissed.
If we don't do anything, I'm not exaggerating. We will lose cases. People will walk out the door. That is the reality that we are facing. That is no one's fault.
Thank you, Madam Chair.
Thank you.
Thank you, Mr. Howell. Thank you, Senator. Are there any other questions for our proponent conferees from the committee? Seeing none, then do we have any neutral conferees in the committee meeting room or online? Seeing and hearing none. Committee, we do have 3 opponent conferees who are scheduled to provide oral testimony. I do not want to cut their time short. We have given wide latitude for the proponents. So I'm going to profusely apologize to our opponent conferees, and we'll continue this hearing so we can have the full amount of time afforded to those opponent conferees. We'll continue this to tomorrow then, committee, where we will hear from the opponent conferees, and we'll have full time to ask them any questions from the committee. We do have an opponent written conferee in your materials as well. Again, I profusely apologize, but this is a big issue, as you've heard. We've had all across the state, we've had conferees appear here in the committee meeting room or on WebEx to discuss this issue, all the way from Sheriff's Association to county attorneys, and the Solicitor General's office gave written proponent testimony. So with that, I will ask our opponent conferees to appear again tomorrow and to provide their testimony. WebEx is fine for the conferees. And with that, then, I again thank everyone for their time today, for coming to the Capitol or appearing on WebEx. Senator Haley, yes.
Thank you, Madam Chair. Since you have, there's a meeting now tomorrow, will you also be working any bills previously discussed in tomorrow's meeting?
Tomorrow, I think we will limit it to hearing Senate Bill 57, the opponent conferees.
Thank you, Madam Chair.
Thank you, Senator. Any other questions from the committee? All right, seeing none then, we are adjourned. Thank you, everyone.